URDG 758 on demand guarantees, assignment of proceeds. Whether or not the guarantee states that it is transferable, beneficiary may assign any proceeds to which it may become entitled to under the guarantee for a valid claim. Whether or not the guarantee states it is transferable, beneficiary may assign any proceeds to which it may become entitled to under the guarantee for a valid claim. Guarantor shall not be obliged to pay any assignee any amount under the claim proceeds unless so consented. Whether or not the guarantee states transferable, beneficiary may assign any proceeds to which it may become entitled to. Guarantor shall not be obliged to pay an assignee the proceeds unless so consented. Transfer of a guarantee. A guarantee is transferable only if the guarantee specifically states. Transferable means it will be made available by the guarantor to a new beneficiary at the request of existing beneficiary. New beneficiary is called transferee, existing beneficiary is called transferor. Guarantee may be transferred more than once for the full amount. Counter guarantee is not transferable. Guarantor is not obliged to give effect to a transfer. Guarantor will explicitly agree to the extent and manner in which to give effect to transfer. Transferor has provided a signed statement to the guarantor that the transferee has acquired the transferor's rights and obligations in the underlying relationship. Transferred guarantee shall include all amendments to which transferor and guarantor had agreed. Transferor shall pay all charges incurred for the transfer. Demand and any supporting document shall be signed by transferee. Name and signature of the transferee may be used in place of name and signature of transferor. So guarantee is transferable only if the guarantee specifically states so. Transferable means it may be made available by the guarantor to the new beneficiary at the request of the transferor, existing beneficiary, provided transferor has provided a signed statement to the guarantor that the transferee has acquired the transferor's rights and obligations under the relationship. It can be transferred more than once, and guarantor is not obliged to transfer, and transfer is only to the extent and manner in which guarantor is explicitly agreed to. Counter guarantee is not transferable. All amendments are included, all charges to be paid by the transferor, and the demand and the signature can be that of the transferee. Governing law. Unless otherwise provided in the guarantee about the applicability of a specific law, governing law of the guarantee shall be that of the location of the guarantor's branch that issued the guarantee. Governing law of a guarantee shall be that of the location of the guarantor's branch that issued the guarantee. If the guarantee is subject to URDG, governing law of the guarantee shall be that of the location of the guarantor's branch that issued the guarantee. Governing law for the counter guarantee shall be that of the location of the counter guarantor's office that issued the counter guarantee. That is why in guarantees we used to write subject to English law, etc. If nothing is written, and if the guarantee is subject to URDG, the law of the location of the guarantor's office that issued the guarantee will apply. Jurisdiction. Any dispute between the guarantor and the beneficiary relating to the guarantee shall be settled exclusively by the competent court of the country of the location of the guarantor's office that issued the guarantee. Any dispute between the guarantor and beneficiary relating to the guarantee shall be settled exclusively by the competent court of the country of the location of the guarantor's office that issued the guarantee. If the guarantee is issued in France by a branch within Paris, then the laws that are applicable, French laws that are applicable in Paris will apply to that guarantee, and the competent court at Paris, maybe High Court of Paris, maybe Commercial Court of Paris, the competent court at Paris shall decide the disputes related to the guarantee issued at Paris. So that is what a competent court could be, a different court for the guarantees purposes. And so you would have seen guarantees saying subject to the High Court of London in UK. Likewise, any dispute under the counter guarantee shall be settled by the competent court of the country of the location of the counter guarantor's office. Otherwise, it has to be specifically indicated in the guarantee. Model form for demand guarantees. This model form is part and parcel of the URDG, and it is as an annex available for 758 version. The guarantee should state who is the issuer, the name and address of the signatory, and the contact details. for clarification or presentation of claim. It should specify the date on which it is effective so that the effective date and validity can be calculated. The place of presentation and place of payment should be indicated. The type like advance payment or bid should be indicated. To whom it is transmitted should be mentioned. The name of the beneficiary and the address of the beneficiary should be clear to understand who has the right to claim under the guarantee. Reference, the underlying contract reference as well as the reference number of the guarantee should be indicated so that the claims can be identified as well as the underlying relationship can be identified. The beneficiary, the party who is having the right to claim, should be identified. The maximum amount and currency should be indicated. The documents required should be listed in support of the demand for payment. In any case, demand is required, and in any case, a supporting statement is required. So, demand and supporting statement need not be explicitly stated if it is subject to URDG. The place for presentation, the form for presentation, is it paper, is it electronic, if it's fax, is it SWIFT, which SWIFT address, in case of email, is it an attachment, if attachment, is it PDF, etc. should be indicated. Expiry date or expiry event should be clear. Charges who will be paying should be mentioned. And two important things, the limitation and undertaking. Limitation is any demand under this guarantee must be received by us at this place on or before this date. This is the limitation, and maximum amount payable will be this. Undertaking is we hereby irrevocably undertake to pay. Irrevocably undertake to pay. This is to say that this is independent and effective and immediately valid. Pay the beneficiary, because only beneficiary should make the claim, any amount up to the guarantee amount. So the maximum amount and currency is capped. Upon presentation of the beneficiary's complying demand, so a presentation of a demand is required for in the form of presentation indicated above. So it is indicating whether it should be electronic or paper and what supporting document should be there. And in any event, a beneficiary's statement indicating in what respect the applicant is in breach of its obligation under the underlying relationship. This is the most operative part. The claim should have an indication as to in what respect the applicant is in breach of its obligations under the underlying relationship. And then the claim has to be compliant. And then the undertaking says we will pay. So thus we have had a quick, fast refresher session on uniform rules for demand guarantees. Thanks for watching this video. Hope you enjoyed and hope this has been an eye-opener. For details, suggest do a thorough reading of the URDG booklet published by ICC. Thank you.